What is the holding of Roe v. Wade in 30 seconds?
Well, the holding of Roe versus Wade in 30 seconds, Senator, is that a woman has a right to an abortion. It developed a trimester scheme in Roe that specified when the state interest and when the women's interests tend to prevail.
Okay, so let me just break it down. The court said that there's a right to privacy, that the government can't interfere with that right in the first trimester. Beyond the first trimester, the government has more interest as the baby develops. Is that fair to say?
That was the scheme set.
And I think medical viability was the test that the court used.
Well, that's the test that the court came around and applied in Casey in 1992.
Okay.
And so viability became more of the touchstone rather than a rigid.
Is it fair to say that medical viability in 1992 may be different than it is in 2022 medically?
Senator, I'm not a scientist or a doctor.
I would suggest that medical viability may change as science progresses. So you may have people coming in and saying, in light of scientific medical changes, let's look at when medical viability occurs. That's one example of litigation that may come before you. I have legislation that says at 20 weeks, the unborn child is able to feel excruciating pain, and the theory of the legislation is that the state has a compelling interest to protect an unborn child from excruciating pain, which is caused by an abortion. I'm not asking you to agree with my legislation. I am saying that I am developing, we're one of 7 nations that allow wholesale, on-demand, unlimited abortion at 20 weeks, the 5th month of pregnancy. I'd like to get out of that club, but we're going to have a debate in this body, in the House, about whether or not we want to change the law to give an unborn child protection against excruciating pain at 20 weeks, because you can, the standard medically is that if you operate an unborn child at 20 weeks, the medical protocols are such that you have to provide anesthesia because you don't want to hurt the child in the process of trying to save the child. So medical practice is such that when you operate an unborn child at 20 weeks, which you can do, you have to provide anesthesia. And my theory is, well, let's just look at it the other way. Should you allow an abortion on demand of a child that can feel excruciating pain? Is that what we want to be as a nation? Does that run afoul of Roe v. Wade? I'm going to make the argument that there's a compelling state interest at that stage of the pregnancy to protect the child against death that is going to be excruciatingly painful. You don't have to say a word. I'm just letting everybody know that if this legislation passes, it will be challenged before you. And you'll have to look at a new theory of how the state could protect the unborn. And here's what I think. You'll read the briefs, look at the facts, and make a decision. Am I fair to conclude that?
Senator, I can promise you no more than that, and I guarantee you no less than that in every single case that comes before.
Well, this is a real-world situation that may develop over time because 70-something% of the American people side with me on the idea that at 20 weeks we should not be in the club of 7 nations that allow abortion on demand, because that's in the 5th month, and that doesn't make us a better nation. There'll be people on the other side saying, no, that's an erosion of Roe, and it will go to the court, maybe, if it ever passes here. And the only reason I mention this is that everybody who wants to challenge whatever in court deserves a person like you. A person like you, no matter what pressures are applied to you, will say over and over again, I want to hear what both sides have to say. I want to read their legal arguments, look at the facts, and I will decide. That, to me, is reassuring. And that's exactly the same answer I got from Sotomayor and Kagan.